to spend some time with us, which is just absolutely delightful to me. So thank you all.
Well, thank you very much. I am delighted to be here. I'm glad to get the invitation. And I really don't know what it is that you all would like to know about our judicial system and what I do, but I'm more than happy to answer any questions that you have. But before I do that, let me just tell you a little bit about Massachusetts and our trial court system, because it's a bit unique. Can all of you hear me? Yeah? So it's on. I usually don't need a microphone, but in any event, Massachusetts is one of, I think, 11 states that do not elect their judges. So most states across the country elect their judges in one form or another, whether they're the appeals court or the trial courts. In Massachusetts, we don't. We're nominated and we're confirmed and appointed, and they're lifetime appointments. In our trial court system, we have trial courts, such as probate, that handle divorces and wills. We have housing court, which obviously deal with evictions and tenancies. We have land court, which deal with issues specific to property and real estate and real property. We have our district courts. We have Superior Court. And then after that, we have an appeals court and our Supreme Judicial Court, which is also an appellate court. So I'm a member of the Superior Court. And in our court, we have 82 judges across the state in 20 courthouses. And we have general jurisdiction, or concurrent jurisdiction, what's called, with most other courts on most things. So we handle civil and criminal cases. We handle all civil cases that the damages exceed $25,000 or more. We have all appeals from state agencies. We have all criminal felonies, although typically we have jurisdiction over all crimes, but most of the crimes are felonies for which there is state prison term. And we have exclusive jurisdiction over first-degree murder cases. So I was appointed 2 years ago, maybe last week or so. And so I've been on the bench for 2 years. And the way we do our rotations are, we do 3 months, and we do both civil and criminal. And I could be anywhere in the state. I happen to be from Essex County, so this was easy for me. So I'm typically in Essex County. Usually, right now I'm in Salem, but I could be out in Worcester. We could be out in Boston, which is sort of where we're headquartered. But because there are so few of us sort of north of Boston, even though I'm relatively new to the court, not that people don't like coming up this way, but it's inconvenient for them. So it's easy for me to get the rotations, whether they be in Lawrence or Salem or Newburyport, which is where our 3 superior courts in Essex County reside. So during the months of February and March, we have judicial outreach. And it's been growing over the past few years. We come to councils of aging such as this. We'll go to schools. We'll go anywhere where people want to ask us questions or are interested in speaking to us. And so that's sort of the tour that we've been on recently. And so when I was called about this group, I was thrilled and delighted. I didn't know exactly what it was, and I'm sure there are a lot of you that have different questions about different things. So no one said come and speak about anything specifically. But I figured I'd give you a little bit of a background as to how our system runs, in our court in particular, and then just answer whatever questions that you might have. I think that there are a lot of there are a lot of misunderstanding, I think, about what we do, how we're appointed, because we're not elected, and sort of the decisions that we make, especially in criminal cases. Because typically, even though we're handling very serious civil matters, medical malpractice cases, or contract cases, or construction matters, or a whole host of things, discrimination cases, The papers typically pick up on the criminal cases, which makes sense, you know, issues of public safety. So most misconceptions arise out of those cases and things that you may or may not read about in the newspaper. So I find that typically people want to ask about criminal matters more than they want to ask about civil matters. But I'm happy to answer either of those issues. So, does anyone have anything? Go ahead.
I have a question
Sure.
for you. If you rotate every 3 months between criminal and civil, how do you bring yourself up to speed when you do that transfer?
You guess? No, I'm just kidding. Our rotations are 3 months, but they're not necessarily. You don't necessarily go from a criminal rotation to a civil rotation. So when you first start, they stick you strictly in civil, even if you've had criminal experience. I was lucky. I practiced my practice. I handled both criminal and civil cases, so I had some familiarity with both. Oh, thank you. But even those judges who come solely from a criminal background, either criminal defense attorneys or prosecutors, they're still put into a civil session first. And I think that the reason is that it's easier to fix something in a civil case when you screw it up than a criminal case, because in criminal cases we're dealing with people's liberty, you know, and we're dealing with public safety, and you're incarcerating people, and we do our best to get them all right, but it's easier to start on the civil end, because if I were to make a decision that was wrong, they could always bring it back before me. I mean, sure, money matters, in a lot of these cases, really that's what it's about, and damages matter, but I always have an opportunity to rethink maybe that decision if someone brings something to me that I didn't see or didn't know, and I can always change that. I can certainly change it on the criminal case as well, but someone's been sitting in jail for 6 months or a year, so we start that way. And with respect to the cases, how you have to know where to go to get the information, because what we do is so broad that no matter what you did in civil practice and what your experience is, there's no way you could have handled everything that we see. So you have to rely on your own research, on the research of your research lawyers, and you rely a lot on the lawyers, the attorneys that come before you, because they know their cases better than I do, and oftentimes you're educated by them. So and believe me, it's a good question, because I can't tell you the number. I just there's a new colleague of mine, and she was just appointed, I think last month, and she's from Essex County as well. And you know, her whole experience was as a prosecutor and then criminal defense work. So they threw her into a civil session, you know. But you get up to speed. We do a significant amount of continuing education and trainings. We have 2 judicial seminars a year for our court, which are weekend retreats, if you will. And then there's an institute for judicial learning, Flashers Institute in Worcester, and on varying topics, they have regular seminars and trainings. So you do your best to keep up, and hope you don't screw it up too bad.
What happens if you say every 3 months? What if you're in the middle of a case?
That's a good question. So we, if I were on trial in a case, I would stay, you know, you'd finish that out before rotating. And we try not to schedule long trials on that last week, because we know that people are going to be rotating out. But oftentimes you just have to keep the case sometimes. So, and as an example, I had handled the case, a pretty complicated case, when I was in Lawrence in the civil session. And then I was over in Salem. I'm over in Salem now, sitting criminally. And issues came up on that case, and the judge sitting civilly in Lawrence wasn't going to be able to hear it because of his docket until April or May. The parties really needed to get in to discuss these issues and resolve them. So I said, send it up to me. I'm familiar with it. I took an afternoon off of my criminal session and I handled that. So You know, we typically don't keep cases, but it's not uncommon to have lawyers and parties come up to another court, even if in a different county, to address a particular case, because you may have written a decision on it, or what happens a lot is you make a decision, you move on, and they file motions for you to reconsider that decision. And so then you have to get the file brought over to, if you're Middlesex or in Norfolk or whatever it is, and handle it there. So that's not uncommon. You know? So, yes?
2 questions.
Sure.
One is, do all your cases go to jury? And the other question is about how long does a case usually last?
No, not all cases are jury matters. So at any time, the parties can choose to have the case tried before a judge. There are certain cases for which you have a statutory right to a jury trial, and there are other cases where you don't. So even there are some instances where a party may want a jury trial, but may not be entitled to a jury trial. So you start out, the presumption is always jury, though. It's just the nature of how we do things. And then it depends on the case how long it takes. So a medical malpractice case may take, 2 to 3 weeks. A murder case could take a couple of days, or it could take a month. Drug cases typically don't take too long, a few days. So it all depends. It depends how complicated the case is. Some cases may be serious, the nature of a criminal charge, for example. It might be kidnapping. But just because the case is very serious doesn't mean it would take long to try. So say there was an alleged kidnapping of one person, and you have that one person testify, perhaps, and you have a police officer testify, that might be it. So even though the cases are serious, they don't necessarily have to be long. But usually, and oftentimes they're longer in the civil session. Like a medical malpractice case, you're talking about a lot of experts, a lot of witnesses, and sometimes it takes longer because on the civil side anyway, we try to do half days of trial, because even while we're on trial, we still have motion sessions in the afternoons. So there are other cases coming in. So sometimes they take a little longer days-wise because you're only going half a day, for example. So it really varies. But usually in Superior Court, I would say the average is about a week. Sure. Anyone have any? Yes, sir.
Yes, could you talk about juror service?
Sure. What would you like to know about juror service?
As someone who gets called, what should I know?
Know how to get out of it? Is that what you're going to ask? Well, so juror service. In Massachusetts, you get called for one trial or one day. So if you don't get picked that day, you're going to be released. If you do get picked, it could obviously be a lot longer. Typically, you go in and you're going to see a video. These days, judges address jurors initially. I don't know if that's always been the case, but it's trying to. We try to. When I'm picking a jury, I like to greet the jurors. So if you've been before, right, you go down to that big jury room. I don't know if you've seen the video or not. They give you a video, right, and you wait around a lot. And there's a reason for that, but you wouldn't necessarily know it. So I don't know if, in your experience, you've had judges come down and meet that jury pool. And I like to do it because I give some people an example. Well, I tell people why I think it's really important. And I know you're down there and you don't know what's going on and you're waiting around. There's a lot of wasted time. But you should know that we realize and appreciate that it's difficult on you and your families. It interferes with work schedules, a whole host of things. We get it's an inconvenience. But really, other than voting, and quite frankly, I think it's more important than voting, because the decisions you make as jurors, and we all have to make them, I have to say, really has an immediate effect and impact on the lives of the people that you're judging. And that's what you're doing, you're judging. You know, I might be the judge of the law, but jurors judge the facts. And it is a system that we inherited from the British common law. And in Britain, or in England, in around the 11th century or so, 11th, 12th century, they started moving away from trial by combat and trial by ordeal, and started moving towards a jury trial system, at least in the most important or serious matters. It was such an important concept that it was written into most, if not all, of our colonial charters, and then subsequently written into our state and federal constitutions. And it's really an egalitarian and democratic concept if you think about it. It's the idea that if we are charged with a crime by our government, or we have a dispute with a neighbor, we don't want a judge to make the decisions on the facts of those cases. We don't want the government to do it. We want people from our community, our fellow citizens, who have no stake in the outcome and who are presumably unbiased to make those decisions, and we live with them. And I tell people before they go up that I am a first-generation American. So my parents came over in the early 60s from Cuba. My father was a political prisoner in Cuba. He was rounded up on the streets and thrown in jail. And he would have loved an opportunity to address his grievances with his fellow citizens, and he even never got that opportunity. And so I understand what an inconvenience it is. But you know, today it's somebody else, and tomorrow it might be you or me. And believe it or not, even in those instances where you sit around half the day, and then they come in and say, by the way, you're all set, we don't need you, it's because cases that have been scheduled that day to go to trial are resolving. And the reason they're resolving is because they know that there are citizens there ready to hear the case. You know, oftentimes, and I used to do this as a defense attorney when I had criminal cases, you know, you prolong the case as long as you can sometimes, especially if your person is not in custody, your defendant, because you know, witnesses forget things, they don't show up, all sorts of reasons. And you push it and you push it. And sometimes you show up knowing that there's no jury available, it's not going to be heard, there's no incentive for you to resolve the case. But when people are there and they're ready and willing and able to serve, all of a sudden the rubber meets the road and you either decide to do something now or you take your chances at trial, which is everyone's right. But it facilitates cases. And it happens on the civil side too. You find cases settling right at the last minute because there are people there waiting. I mean, a defendant in a civil case that's going to pay money to a plaintiff who's brought suit is going to hold on to that money as long as he or she can, whether that be an individual defendant or an insurance company or whatever. I mean, why would I write a check today if I don't have to write it for another 6 months or a year? Well, when you're there and you're ready to hear a case, they tend to settle. I tell a story just I think it was last January, not this past January, but the year prior. I was sitting in Newburyport. And in Newburyport, I don't know if you know this, but we're all Essex County folks. So Newburyport Superior Court is the oldest continuous active courthouse in the country. Daniel Webster argued cases there. And it's still there, and we still hear cases. It's one courtroom upstairs. It's drafty, you know, but it's great. And as a lawyer, I only had a couple of things. I had an appeals case there once, and I had a civil matter there once. But anyway, I do like sitting there. So I came down to greet the jurors, and in Salem, you know, we have this large judicial complex, right, with all sorts of courts in there, and we take turns going down and greeting jurors. But in Newburyport, you're the only person there. So I went down to greet jurors, and seated in, you know, the jury seats, just like you would be, was Associate Justice David Lowy. Now, Justice David Lowy is an Associate Justice of the Supreme Judicial Court. That's our highest court. And he is an Essex County person as well. So he's sitting there, and the jury pool. Interestingly enough, our seats on the Superior Court are all numbered. I couldn't even tell you what number I am, but our seats were commissioned by the legislature. So, whatever number it was. And when you are inducted into the Superior Court, there's a ceremony, and the Chief Justice gives a history of the seat that you're now going to occupy. And in my particular case, there were 3 judges prior to my taking the seat. The first 2, I can't even remember the names. I couldn't even tell you. Although one did go to the appeals court. But the last judge to hold the seat before I got it was Justice David Lowy, who was appointed to the Supreme Judicial Court. His seat became vacant, and they appointed me to that seat. So, in any event, we're in this jury room, and I give my spiel, just like I do to every potential juror. And would you know that he came upstairs, he was selected to sit on that jury until 4 o'clock that afternoon, when the last lawyer with his last challenge knocked him off the jury. So he was there, ready, willing, and able to serve, just like we all have to. And I'm glad, quite frankly, because I didn't want my case to go up on appeal. He'd probably have to recuse himself in any event. But he was there, and he spent the whole day, and so everyone has to do it. But I am also pretty sensitive to people's hardships. I think some judges, I don't know, we all have different levels of tolerance for people's nonsense. And oftentimes you can tell if someone's really just saying anything they can just to get off of jury service. That doesn't sit all that well. But I'm particularly sensitive to people who are self-employed, who are hourly earners, who have child care issues, single parents, that sort of thing. So I'm pretty lenient, I think, in that respect with letting people off of jury service for hardship. I find that if you let them off pretty quickly, I mean, you just get a jury more quickly. I mean, a lot of times, folks that you let off are not going to be able to sit anyway. It makes no sense to spend 15 or 20 minutes trying to convince someone. And there are other reasons why people won't sit either. We want people who are unbiased, who have no prejudice, who can, even accepting their own life experiences, follow instructions and follow the law. And and sometimes the case might involve a police officer. It's vitally important to that particular case. And people say, look, I have 3 uncles who are all police officers. My dad is a police officer. I'll do my best, because one of the questions I always ask is, would you tend to believe the testimony of a law enforcement official more than you would anyone else just because they happen to be in law enforcement? And some people say, well, I'd like to say no, but everyone in my family is in law enforcement. And I see what they go, and it'd be hard. I'd try. Well, I appreciate that honesty, but that person isn't right for this job. Sometimes you have terrible sexual assault cases where jurors come up and for the first time they disclose abuse that's occurred to them. Right there, for the first time when asked about it while sitting, while picking a juror. So it's an interesting process. I know, like I said, I know it's inconvenient, but you know what? Actually, my favorite part of this job is speaking to jurors after they've served. Yeah. So as a lawyer, I never had that opportunity. Massachusetts it's odd in a lot of ways, but in one way that it's a little different than other places is that, at least when I was practicing, we're not allowed to speak to jurors. Now that's changed in the past several years. So now on motion, people can try to communicate with jurors, and it's done more frequently. But when I was practicing, it was never done. I never got the chance to speak to jurors. And it's great now. I find that most people appreciate the service. They're happy they did it. They do it again. I mean, they're not rushing up to the courthouse steps to do it next week. But they really appreciate it, and they get a real sense of what the process is like. And I think they go away with an appreciation, and more importantly than that, they go away with the understanding that they've done something very valuable. And I can't speak to other courts. Every case is serious, and every case is important to the litigants, however small it might appear to us. But at least in the Superior Court, we are dealing with really serious things. And so I think that when people serve on juries for an alleged rape, an alleged murder, an armed robbery, a medical malpractice case, I think when they leave there, they feel like they've accomplished something. They've something really worthwhile. And again, those decisions have immediate effects on our fellow citizens. So that's probably the best part of this job for me. And I didn't even realize it would be until I started doing it. But speaking to jurors afterwards is great. It really is. Yes, sir.
Isn't there an age limit on juries?
Yes. Well, no, there's no age limit. But if you're 70 years old, you don't have to serve. But what's interesting is that most people, those aren't the people that are looking to, begging to get off, quite frankly. It's an option, but I find that most people 70 or over that show up believe it's their civic responsibility and duty. They're happy to be there. And I don't get many requests for that. I'm sorry? It's true. Yeah, that's part of it. But sometimes, someone might come in with a disability, might make it difficult, and I'll tell them, you're not obligated to serve under the law, but certainly I would never exclude someone because they're 70 or over. Yeah. Yes?
I'm going to ask another question.
Sure.
Have you ever been sitting on a case and in your mind you've decided innocent or guilty and the jury doesn't agree with what your mind is saying? Has that happened to you?
Yeah. But that's not my job or role or responsibility.
Yeah, I know, you can't say anything. But
Well, look, the truth is, if something were so outrageous, I can throw out a jury verdict. It is something that is not done very often. It would have to be unusual circumstances. But it could happen, and it does happen. But the issue isn't whether I could find that the Commonwealth proved someone guilty beyond a reasonable doubt. It's whether any reasonable jury, any reasonable trier of fact. So the truth is that I may feel one way, a jury may feel another way, and another jury might feel another way. It happens all the time where we have mistrials because a jury cannot come to a verdict. Our verdicts in criminal cases have to be unanimous. A jury can't come to a verdict, so they have to retry the case. Another jury may find that person guilty or innocent, or not guilty. So that does happen. It happens a lot, actually. Yeah.
Today there's a lot of discussion about sentencing.
Yes.
What is the policy for Massachusetts courts for the judge to sentence the guilty party?
Sure. We have a tremendous amount of discretion in sentencing. Now, having said that, there are certain cases in which there are minimum mandatory sentences. The legislature has seen fit that, for example, trafficking in cocaine, trafficking in fentanyl, mandates a minimum mandatory sentence. There are other cases that have a maximum penalty. So let me think. So I think armed robbery, for example, has up to 20 years in state prison. Now, up to 20 years in state prison. And the way we sentence, by the way, we have, with respect to jails, there are two options. There's House of Corrections, which is like in Middleton House of Correction, right? County jail, or state prison. There are some offenses for which you can only get misdemeanors. You can only get House of Correction sentences. There are offenses for which you can only get state prison sentences. Armed robbery, for example. And then there are certain charges for which you can, there are both a state prison term and in the alternative, you could sentence someone to county jail. Now, with the minimum mandatory sentences, I have no discretion. So if someone is convicted today of trafficking in a Class B substance, cocaine, for example, and trafficking by its nature has to be the selling of over 10 grams, possession with the intent to distribute over 10 grams, I must sentence to at least 3.5 years in state prison. On cases like rape, which is up to life in prison, I could give life, I could give probation. That's a big difference, right? So we do have a lot of discretion. Now we do have what are called sentencing guidelines. But those are not mandatory. And those of us who have done this for a while, I mean, we look at them. What they do is they slot people in for the type of offense and prior record and age and that sort of thing. But the truth is that sentencing isn't cookie cutter. And those guidelines don't take into account a whole host of different things. Someone's upbringing, someone's mental illness. It just doesn't. It doesn't take into account everything, but it's there to help. It's one tool. So we have a lot of discretion in sentencing. And remember, our sentencing, and you may have heard about federally. I think the president just signed recently a criminal reform bill, right? But that's on the federal side. So those are federal sentences, which have nothing to do with anything that we do. Governor Baker, I think in April, signed a new criminal reform bill in Massachusetts that, for example, trafficking in fentanyl, until April of last year, did not carry a minimum mandatory sentence. So you could sentence up to whatever, 10 years, but you could also give them less than what you can now, what you have to impose now, which is a minimum mandatory sentence. So there's a lot of discretion, and it varies greatly, and it's a very difficult thing to do. I currently am in the first session in Salem, and what the first session means, that's an arraignment session. So it's sort of the first place people come once they've been indicted or charged in the Superior Court. So we see a lot of bails and bail requests. We see a lot of hearings to detain people on dangerousness. We see a lot of lobby conferences, which is an instance where the defense attorney and the prosecution will come in and say, Judge, we'd like you to give this sentence. And the defense attorney says, no, Judge, we'd like you to give this sentence, and here's why. And so you have those lobbies. And then there are a lot of pleas. So a lot of people are pleading guilty, and they are negotiated with the Commonwealth, the prosecutors, and their joint recommendations. Now, I don't have to accept a recommendation that's made, but I typically do.
Do you have to explain what your decision is and why?
That's the best practice. I try to for a few reasons. If it's on the record, people, I think you owe it both to the public, the taxpayer, the defendant, and the prosecutors to explain why you're doing something. So I start from that premise. But then also, if down the road there's a question, well, Taqbit sentenced someone to this. I mean, what a lunatic. You can always go back to that record and see and hear the reasons why that was done. And I think that that's helpful too. And you don't want people to think that you're just sentencing on a whim. I don't think that would serve anyone. So yes, I try to explain all of my reasons on the record to the best I can. And I may do so a little bit more than others maybe, but there are others that write a lot. So we have these things called detention hearings under a particular statute, where the Commonwealth asks that we hold somebody without bail because they're dangerous. I make those decisions, and I make written findings because I sort of have to on a pro forma sheet. I mean, there's a sheet you sort of check off things, and then I'll put on the record the reasons. I have colleagues that will actually write a decision out on that, and I have some that just use the sheet itself and really don't give much more explanation than the sheet. So it depends on the judge, but I think it's important to the best you can to explain your reasons. You know. Yes.
They're appointed for life, right?
Yes.
And these are all of our judges that are appointed for life.
Yes.
So I don't remember the cases, but what happens when a judge makes a decision that outrages the public so much? And there's been cases like that in Massachusetts.
Sure.
What consequences do they ever suffer?
Well, I mean, this is an important question because it goes to the issue of judicial independence, right? We are not a true democracy, right? We're a republic, or a constitutional republic. That means that people have rights that are not popular with the public sometimes. And I would argue that because I'm appointed for life, and because I don't have to concern myself with the fact that I may have a majority of people who don't like something voting me out of office, I can make a decision based on the law and my conscience, and do what I believe is right in accordance with the law, not just because I happen to think it happens to be right. So there are consequences, but not when a judge acts within his or her discretion. So in other words, if a person is convicted and I have the option of sentencing, so let's take a hypothetical case where a person is convicted and the maximum sentence is life in prison. And my options are anything from 0 to life. And that's what the law calls for. And in my discretion, I choose probation. That's perfectly legal. It's within my discretion. It's compliant with the law. The fact that a majority of people may think that I'm crazy because I let this person out, that's not grounds for removal of a judge or discipline of a judge. Now, if I did something that was not in my discretion, or if I did something that was contrary to the law, then yes, that would be a violation of our ethics and judicial code of conduct. For example, let's say someone was convicted of murder. Now, in Massachusetts, anyone convicted of murder is sentenced to life without parole. Let's say they're convicted of murder and I give them probation. I mean, I can't. It's illegal. It's an illegal sentence. You know, we do have complaints filed against us, against the to the Judicial Conduct Commission, and they get reviewed. And there have been some judges who have been disciplined very severely, some who have been impeached, though that happens very, very, very rarely. You know, there was an incident you may have read about recently in the last couple of years where a judge out in Western Mass was having an affair with a court employee, and he was suspended without pay, and I think they didn't go through the impeachment process, but where it was headed, and the Judicial Conduct Commission recommended that suspension stay in place. The Supreme Judicial Court agreed, and that judge then resigned. But even if we have matters before the Judicial Conduct Commission, ultimately it requires impeachment. It requires an act of the governor and then the governor's council, which is the council that votes on the governor's appointments. But oftentimes, too, the public is outraged, sometimes because they're not fully aware of what the law is necessarily. I can't tell you the number of times I've come home and my wife says, "What do you know? I read so-and-so, are you out of your mind? What happened? You're crazy." And you say, "Well, wait a second, let me explain," And then she says, "Well, no one tells us those things." I said, "Well, that's why we do judicial outreach," I said, to explain to folks. But so it's very difficult, but there is a mechanism for
But it would
it.
make sense then if that judge made a decision so contrary to what the public says, that maybe they should explain it to us.
Well, yes. So here's part of the problem. Be careful. So our code of judicial conduct prevents us from discussing cases, pending cases. I have a problem with that because I think that I could stand here and tell you, if I've put something on the record about why I did something, explaining to you what I've already said in public shouldn't be an issue. But there's some debate on that. So what oftentimes happens is there'll be a report in a newspaper about a decision a judge made. The reporter calls that judge. The reporter knows the judge is going to say what we're all instructed to say. We have no comment. Talk to, the talking head in Boston. And it's unfortunate because I think it does. Look, I have a lifetime appointment. You pay my salary. I may not owe you the decision that you want, but I do owe you transparency and an explanation for what it is that I do what I do. We try to do that, but it's really, really hard when you're sitting. So what happens is we have, believe it or not, a media arm, I don't know, a person who is the media liaison. So anytime these things happen, you might get a press release. I'm not sure that's all that effective. I'm not sure how much the public sees or reads that. And I'm sure the public would rather hear from me about why I made a certain decision than some paid consultant. So I get it, and we're working on that. I'm trying to get people to come into the 21st century. Because the truth is that with social media these days, that anything that is said can go viral like that, any opinion. So we need to do a better job, and I think that that's one of the reasons that we're out talking to groups like this and schools and anywhere we're asked to go to explain why it is that we make the decisions that we make. And a lot of I think that a lot of the decisions that you're referring to a lot of times have to do with issues of bail and people being released and not held on a high bail. And it's funny, it's one of the instances where I talked to my wife and she said, how could someone release someone on $1,000 bail? And there's a presumption, besides the presumption of innocence, right? Which we either adhere to or we don't. There is a presumption of personal recognizance in Massachusetts. So bail is not for the purpose of punishing people or holding someone. It's to ensure that person's return to court. So when you are accused of the most awful crime, It sounds terrible, but it's still just an accusation. And it is unconstitutional to hold somebody, an innocent person, because remember, you're innocent until you're finally proven guilty, just on the mere accusation. And so if there's a person who has committed a terrible, alleged to have committed a terrible crime, but they have a strong working history in the community, they're active, they're not going anywhere, they have no history of complaints before, they have no convictions, they have no history of not appearing in court. I mean, what's the basis, other than the fact that they've been accused of some terrible thing, to impose a really high cash bail? Now, certainly the fact that someone's accused and charged with something very serious suggests that if convicted, they're going to do a lot of time in prison. And that is a good reason why someone might flee the jurisdiction. And so, you know, some amount of bail might be necessary or required for those purposes, but we're not trying to punish people by holding them. You know, because what happens if a year from now, the prosecution decides they can't go forward on this case, the case gets dismissed against the person, you have a person not convicted of anything who's now spent a year in prison. So, so we cannot consider, in most instances, we cannot consider someone's danger in setting bail, someone's dangerousness. There are certain, under certain circumstances we can, there are certain specific predicate offenses where if the government believes someone is too dangerous to the public, that there are no conditions of release that will safeguard the public safety, they then bring a motion and you have a hearing on whether someone is dangerous or not, and even if dangerous, whether there are conditions of release that can safeguard the public. So I understand, you're not the, I mean, we get that a lot, you know, and it's a good point. A lot of people just don't, you know, we don't do as good a job as we could or should answering questions and explaining, you know, what it is that we do and why it is that we do what we do. And I think some people think, well, these judges are appointed for life, they don't care, they don't need to respond to us, and that's how they act. And it's not quite like that. Our Code of Judicial Ethics and Code of Conduct prevents us in many instances from responding.
How
Yes.
about the way you handle children who are accused of and arrested for whatever?
When you say children, are you speaking of people under 18 or children, you know, young adults, 20-year-olds, 19, 20?
No, I would say, well, things I've read, I've seen kindergartners who have been accused of things.
Yeah, of course.
And up to 16, 17-year-olds.
Well,
I would say 18.
yeah. So there's been a recent reform in the law in the past couple, 3 years, I'm not exactly sure, that have that's increased the age of juvenile offenders to 18. It used to be that if you were 17 years old and you were arrested and charged with an offense, you'd be treated as an adult. So we have juvenile courts. And in most every instance where a juvenile, someone under 18, is accused of committing a crime, the juvenile courts handle those cases. There are certain cases where a person can be indicted in my court and found a youthful offender. And if it's a youthful offender indictment or charge, which are the most serious cases, then they're treated like anyone else in our court, except that if they were sentenced, they'd be in a DYS, Department of Youth Services facility, until the age of 18. Now, first-degree murder, I think, is completely different. That would come to our court. So I don't see many juveniles. There have been a couple recently who've been charged with murder, and so they're 17 or so, and they've come up to my court. But usually they're handled in the juvenile courts. And their options are different. They do a lot of diversion with the district attorney's office. so that the children don't end up having a record. And if committed, because they've committed, so if convicted, they're committed not to a jail or a state prison, but to a Department of Youth Services facility, like a home. And then if it were a youthful offender case, after 18, I mean, they may get a sentence which requires some state prison time after their stint in the youthful facility. So I don't know that much about the juvenile cases these days, but they're not typically handled in our court.
What about mentally ill these people who are accused of?
Yeah.
How much help do they get?
How much what help?
Help.
I wish they got more. Mental health issues are very significant in our court. They vary. So there are instances where someone appears in court and their lawyer says, look, I cannot communicate with this person. This person is not competent. They don't understand what I'm saying. And we have an evaluation, and if need be, we send them either to Bridgewater or to the Worcester Recovery Center, I think for women typically, to get an evaluation done. Then there are issues of criminal responsibility, which is someone saying, yeah, I'm competent now, I understand what's happening, but at the time that I committed the crime, I was out of my mind. And I cannot be held criminally responsible. So those are issues that are usually fleshed out by that person's attorney. And then there are the issues of mental illness that are unrelated to those things, where, I mean, I'm almost at a loss because you see it so often and you have to do, there are several things you want to do. You need to protect the public, certainly, but you're also trying to appreciate the condition that this person was in when they committed the crime, because that affects how I would sentence somebody. And then you have to consider what you do after. So it is not uncommon for there to be mental health evaluation and treatment. How effective is that? I don't know. But it's something. And so a lot of times someone is being asked to be detained because that person is a danger to the public, and a judge may release that person to a family member, understanding that maybe there was a mental episode that may have caused these actions, and as part of that pretrial release or conditions of pretrial release, you may order a mental health evaluation. Oftentimes after trial or after conviction, if there's probation, you might put someone on probation, sometimes just for that purpose alone, to make sure that there's a mental health evaluation, that there are recommendations for treatment, and that part of the probation is that that person abide by those recommendations. So those are some way, and then the probation department typically will handle that, and then I might not know anything about it unless that person violates their probation and they come back. You know, mental illness affects people in very different ways, but it also affects them at different stages in life. So sometimes, you know, you might have someone who's 38 years old, 40 years old, never had a record, never been convicted of anything, never committed a crime, and all of a sudden they're alleged to have done something crazy. And you try to get to the bottom of sort of why that is, and then also realize that maybe there are there's a mental health component that may never have been addressed before, or maybe it needs to be addressed now because it never occurred before, and you try to do that. So it's not an easy, there's no good solution, but that's how we try to deal with those different aspects of it. Yes, sir.
Yes, at what age does the judge have to retire?
70.
70?
So it's mandatory retirement at 70, and then you can still be recalled. So if judges haven't been appointed and they need you to sit, you can be recalled for a period of time and sit. But we have 70, mandatory 70.
Can you practice law after that?
No. Oh, after? Sure, you could. Yeah.
But not
You can't. No, I can't practice law now. No. In some states, I think in New Hampshire, at least in the district court, depending on the court, you could, but not here. Yes, ma'am.
Do you watch any TV drama series about courts?
About what? About courts?
About courts. And if so, which one, not the Judge Judy, I'm talking about the,
Sure.
the fictional.
Yeah.
And if so, which ones do you think are more realistic, or do you have a favorite, or maybe
That's a good
not watch
question.
them at all?
I don't typically watch them. I don't think any of them are realistic. But I have, so there's a new show recently, it's been a year now, called For the People, I think, on ABC. Yeah. Now, that is, I do watch that one. I don't know why, because it's so, anyway. But that has to do with federal prosecutors and federal defenders. I mean, a lot of it is similar, but what I find about these shows typically is that the way, in the interaction between the lawyers and witnesses are never like you see. Like, first of all, accepting cross-examination, lawyers are not supposed to direct their own witnesses. Lead their own witnesses. So the questions have to be open-ended questions to your witness. That never happens in these shows, but that's and they're never as polished. But I watched that one. I kind of like that one. I'm trying to think. I don't know exactly why I like it. The cases never come to court that quickly, I can tell you that, for sure. I'm trying to think of what else. Law and Order is always pretty good, right? But that has a law enforcement component to it, and then a judicial component, the trial. Yeah, For the People I watch.
What's your personal opinion about our federal Supreme Court having an age limit?
An age limit?
Yeah, we're cut off.
But they don't have one. They don't have one.
They don't have
Right.
one, and would you recommend that they have one? And if so, what age would you say would be the cutoff?
You know what? It's funny. What I've found since getting this job is I'm no longer entitled to my own opinion anymore.
Between us.
Yeah.
Just between us.
You know what? I do not believe in an age cutoff for anything, quite frankly. I think even in our court, I know the cutoff is 70, but if people can do the job, they can do the job. I don't know. I do. Interestingly enough, it's not just the Supreme Court, but I don't think all the federal courts. So, the federal system has their appellate courts, like we do. It has their Supreme Court, like we have our SJC. And they have their trial courts as well. So the federal district courts. And there are no age limits to those judges either. So I wouldn't necessarily recommend an age limit, but there has to be a mechanism by which I think someone can, without fear of repercussions, say, Taqbit's had it,
Hopefully they don't agree.
Yeah, for sure. So, so I think if they can do the job, they can do the job, and if they want to. And never really thought about an age. The only reason I thought about a retirement age for judges is when I got this job, because they told me that I'll be out at 70. But other than that, I've never thought that there should be. Yes,
What do you think about putting television cameras into court?
I'm fine with it. We have them. In the federal courts, they don't, but
Yeah, I know in the smallest case, she's allowing television.
we allow them in our court, and then not just it's not just the, I mean, it's not just small cases. I mean, the murder cases. I mean, Aaron Hernandez in Boston, they had cameras in there. I mean, our courts are open to the public. They're supposed to be, and they're supposed to be transparent. So if you can walk into any court in our state and sit in on a trial of any person, why shouldn't it be recorded? Our major concern is ensuring that jurors, for example, are not recorded, and their faces and that sort of thing. But other than that, the process itself, we have cameras, we have reporters and cameras in my court all the time. Yeah. Yes, ma'am?
Did you ever have a case that you just didn't want to be a part of, and can you remove yourself from it?
Yeah. I've recused myself from cases, but not for that reason. I may have known one of the lawyers very well, for example, or it may have been a former client of mine, or something like that. But not because I was personally offended or outraged or so. I mean, when I signed up for the job, I knew what I was getting, So there are difficult cases for sure. And there are some things you don't want to see or would rather not hear, but it's what we do. So I've never, I can't, and I don't know any of my colleagues that would do or would. When we recuse ourselves, it's because we want to make sure that there's not an appearance of impropriety, that we may have known a witness or something like that, But the actual elements or the facts of a case causing me to get off of it, no, that doesn't happen.
Can you leave it behind when you leave the courtroom?
I can. I don't know how it will affect me down the road. I don't know. I don't know if subconsciously it affects me in ways that I don't see or know. But it's almost, when I was a lawyer, and oftentimes you get the people say, well, how could you have represented X? He or she has done this or alleged to have done that, the worst things possible. And I never thought about it that way because I was focused on doing my job and doing the best that I could. And I was so focused on that I didn't ever let sort of the personal facts affect me emotionally. And similarly, as a judge, you can't let that, you're supposed to be impartial, I'm supposed to be unbiased. I do my best, obviously, to be that way. And that means waiting until you hear everything, accepting that cases take a long time to unravel. What you might think on one day, you may not think the next. And so if you're, so I focus on making sure that my rulings are correct, they're compliant with the law, that I'm being fair to everybody within the context of the law. In doing that, I find I'm not as affected by the very emotional testimony that you might hear from a victim in a case than I otherwise would be. But we're all human. You hear what you hear, you see what you see, and you have to appreciate it without letting affect the work that you do. I guess is the best I can.
So you have a lifelong appointment to the state level.
Yes.
If you have aspirations to move to the federal, would someone be able to appoint that for you, or how would you make the move if you wanted to?
So our federal courts, their appointments too. It's a very similar process, except that the governor appoints us, the president appoints them. The governor's council hears and approves our nomination, the U.S. Senate approves theirs. So it's sort of the same way. But in that instance, they usually have committees. And people may come out of a certain committee and a name or two may go up to the president. It's the same process. It's an application process. And then I don't know beyond that, you know, what the steps are there. But my whole practice in life was in the state system. So could I be a federal judge? Sure, but I never practiced in federal court. I did very little practice in federal court. That's not where my experience lies. And it'd probably be more difficult if that's what I wanted to do than someone who has a lot of experience either as an assistant U.S. attorney or a federal defender, or people who are there constantly trying civil cases. So, but it's a similar process. Ultimately, you know, you come out of somewhere, and the president has to decide that's the person I want to nominate. Just like the governor has to decide that's the person I want to nominate. But it's an application process. Just like I applied here, I'd have to apply there.
Just like a job.
It's like any job, yeah. Anything else? I've kept you. All right, if there are no other questions, so thank you. I really want to thank you. It's been great. It's been great answering your questions. I'm glad you decided to do this, and we do this, like I said, every year. So now that you're on